morning to everyone present here today. I extend a very warm welcome to all of you to the annual Information Security Summit 2023. So we here at the Technology and Public Policy team here at DSCI are very fortunate to be led under the unique vision and able guidance of Mr. Vinayak Godse, sir, the Chief Executive Officer of the Data Security Council of India. So without further ado, to begin today's proceedings, I would like to invite Mr. Vinayak Godse, sir, to address the gathering. Thank you, sir.
Thank you all participants and more important speakers to come and join our public policy day. Is it okay? Are you able to hear me? Yeah. We had definitely public policy effort that since beginning we have been putting together. So when the AISS was formed, 2008, the IT Act came, right? And then after that, 3 years we took to get a first privacy law in the country. 3 years for us to make that rule under one section 43A. But now things seem to be so now accelerated in public policy space. So every Friday, mostly in recent past, and now we are also worried now, like before Christmas, the rules will come and take away a lot of our time because they are not going to give time. 7 days is something the ministers talked about it. Public policy for the ASA now, we are quite a good formidable team. 4 of our members of team members, couple of them, Deepika and Anisha, work in Bangalore, Deepa and Shivangi work in Delhi with Atul also engaged on that matter, and we have some other ecosystem that we built from the various law school plus some of the public policy specific institutions and some of the think tanks, some law firms specifically. So we have been doing multiple things, and team will walk you through. So kind of projects that we have been doing as public policy, kind of areas that we are picking up, and we know when we used to do security and privacy, not much people will be coming because public policy nowadays, now everybody talks about privacy, everybody talks about security. I was talking to one CISO, he said, we don't know how to cook our meal in the evening. so many events are happening in cybersecurity space. So overall, I think one important thing that we are putting an effort from DSA is, can you make more practical in nature? Can you bring this bottom-up thinking into the public policy? So DSA membership is very diverse. It's not monotonous. So we are part of NASSCOM. NASSCOM is more technology industry, but our membership is cutting across. So most of the key banks, 15 top banks are member now. Most of the insurance companies are member now. All other financial sector, the capital sector is member. We have all key energy company or DSCS member, power sector companies are DSCS member now, health sector organization, then now manufacturing company for that matter is increasingly coming. This summit has been quite significant because you have participated so many manufacturers like CIOs and CISOs in this summit basically. And this membership and the DSA membership is also very delivery focused membership. So we spend our time with members. So that's the way the membership has been crafted. That's why we understand the issues much better because we know across sector how things work specifically. So I was with the energy company CIO last week. And cloud is such a challenging part from them because their ministries are pushing them to use cloud, whereas many policies of government of India doesn't allow them to go on cloud. So there's a lot of dichotomy in different policy coming from different sides basically. And actually then using those and looking at a lot of areas where even there's a project that we are working where we are actually saying that can we develop evidences. For example, if we are talking about encryption is a big challenge, and people have been contesting that why can't you look at the originator, why can't we look at the message? Then can we actually implement the signal protocol? And there are 6-7 proposals which came, right? One professor, too many organizations, and actually implement them to show the results. And that's the effort we put together. And so such kind of bottom-up, more evidence-driven, and now for privacy we are doing case study. We are learning experiences and trying to map the privacy expectations to those case studies basically. We did it mapping for health sector organization, for hospitality organization, for startup working in some areas, for even the airline industry, and there are some projects that we will talk about. So we have already developed a privacy seal of DSCI, and we're doing some pilots in different sectors of industry basically. So here we do a lot of those ground practical work from the team perspective, and they'll walk you through the work that we have been doing. But we'll also dwell into some of the areas of public policy, and one of the key areas that we'll deliberating on how this with the DPDP as one step will as a significant next step, because our regime will become rule plus law. But when it comes to actual implementation, and another key challenge is that the technology which is coming in, how exactly the privacy will be shaping the future of technology, future of business, future of even where the industries evolve in the country. Yesterday and last, I think, 2-3 months we have been investing time to understand SIMS 2 for that matter, and what will impact the Indian industry, and we are seeing a lot of challenge out of it. We are now looking at if the obligations for the data and privacy is increased tremendously. So what will that entail to all the business that is being delivered out of India? Or in Indian ecosystem itself, there are a lot of innovation happen, adoption happen, and now suddenly I have recently seen the framework of SEBI on cloud, which is so innovating and restrictive. Many companies has to gone back from whatever they try to achieve on cloud. And then if there are significant obligation, then those obligations are now pushing some of the companies, let's do it internally. We do our own rather than leveraging capability of a startup or some third-party provider. So trying to now invest time in how data privacy, and probably we can deliver a little bit on regulation and the obligations and liabilities that we are talking about would create challenges for the industry ecosystem that we have built. There's a tremendous amount of industry is possible. I mean, in Bangalore, there's one company in Bangalore who manages street lights of some of the big cities of US. Means now, because of IoT cloud, you can manage farms out of India, you can manage factory out of India basically, you can even manage homes out of India basically. So new lines of services which are going to be emerged. And in those new lines of services, there is a lot of value add we do. And then there is value add with this purpose that we add to the work basically. So then the entire consent and the relation between the controller, processor, and consent becomes primary instrument and challenges it creates. So a lot of those interesting, at the same time challenging areas that we are dwelling into as a part of DSCI public policy team, which they will be walking through it. We are also probably launching a small report that we built on anonymization, because that's another area government is looking for standard for it. So we worked on that. So we will be taking you through that as well. Some of the projects also we have planned and we will be planning in the coming future. So we'll be talking about that. So I will now give it to the public policy team to take it ahead from now. Thank you for joining.
Thank you, sir, for that very well-articulated speech, and I think I speak on behalf of everyone, but you really have a way of putting across the excitement which surrounds technology policy in such a well-articulated way. So before we go into the very highly anticipated panel discussion, I would like to also take this opportunity to take everyone through the session flow for today, for everybody's convenience. So to begin with, again, we have the future of data protection in India, a roadmap for regulators. We have this exciting panel discussion in store for you. And followed by which, as Vinayak sir pointed out, we will be making a few very exciting DSCI industry and academia collaborations, followed by which we will be having a DSCI policy showcase to really have a recap of 2023 essentially, to show the excitement surrounding the laws, the regulations and the policy that's been shaping data protection and the emerging technology landscape as well. So followed by which we'll be touching upon another very exciting panel discussion in store for you, which is navigating the regulatory landscape of data protection and artificial intelligence. So without further ado, I would now like to take this opportunity to introduce to all of you our panel of experts here who are here with us today to deliberate on data protection in India, a roadmap for regulators. So firstly, I have the privilege of introducing to all of you Mr. Deepak Maheshwari. So Mr. Maheshwari is a veteran in the field of public policy, and he is now an independent consultant and a researcher in the sector of public policy. We're so fortunate to have you with us today, Mr. Maheshwari. So followed by which, to give you an academic perspective to this discourse, we have with us Professor Indranath. Thank you so much, Mr. Indranath, for being here with us today. Professor is currently serving as a professor in the O.P. Jindal University. And lastly, we have Mr. Siddharth Dev here with us today. Mr. Dev is a manager for public policy at the Quantum Hub. So and to lead this discussion, we have Ms. Shivangi Malhotra, who is an associate at the public policy team here at DSCI. So now I request all the panelists to please proceed to the stage, and I hand it over to Shivangi to lead the discussion. Thank you. Thanks, Deepika, and thank you to all the panelists here for joining us for this session. I'll just set some context quickly. Of course, Vanessa has already done a little bit of that, but before I pose my questions to all of you, I'll set some context for why we wrote this report and why we're discussing this topic today, right? So the past few decades, as we've discussed, there's been a patchwork of regulations on protection of personal data in India, right? It started with the IT Act and the SPDI rules, which were largely unenforced. And we also had sectoral regulators sort of picking up pace and enforcing sectoral mandates on data governance. We had IRDA come up with their guidelines. RBI has issued a bunch of directions and guidelines as well. But a catalyst for change, of course, was the enactment of the DPDPA earlier this year, with the enforcing rules expected to come out soon. So in that background, over the course of the next 45 minutes or so, we'll be discussing what the future of data protection looks like in the Indian context, with now a central legislation having been enacted, right? So I'll now ask each of you, maybe take 2 minutes each, just give your opening statements on what your key takeaways were from the Digital Personal Data Protection Act, especially in the context of industry impact and from an implementation standpoint, right? Like what stood out to you when you read that law. So just 2 minutes each, quick opening statements from each of you. Deepak, why don't we start with you?
Thank you, Ami. Yeah, good morning, everyone. So, I think before we get into the DPDPA, it's important for us to just look at the industry even beyond what we had just mentioned. The whole thing actually started on 25 July 1998. The Union Cabinet gathered and says that we'll have a data protection framework in 6 months. And if that was the case, we would have it.
Can't hear.
Okay. It is working now. Thank you. Thanks, Vijay. So, the whole thing started on July 25, 1998. There was a cabinet gathered saying that we'll have a data protection framework within 6 months. And if that was the case, we would have had one by the eve of the Republic Day on 1999. Okay. Is it better? No. So that's one thing. Second thing is, initially the whole thing was about talking about a Privacy Act in 2010 or so, and that was being done by the Department of Personnel and Training and not by MIT. That book went on. Then Niti Aayog started something which was prior of that called Planning Commission in 2012. They had an expert group. They had their own recommendation. And the thing that Vinayak talked about, the rules that were notified of on 11th of April 2011, after the Act got the 2008 amendment under Section 43A. So yes, even that did take a lot of time. So today when we are looking at DPDPA, I think the three important things for us to look at this point in time. Okay, this is one. Okay. Number one, the Act is yet to be notified. I am repeating it. Act is yet to be notified. A lot of people are under misconception that on 11th of August, just because it was published in the Gazette, it got notified. No, that was only for information. Please go and read that Gazette again. Okay. So it was published for information. The Act is yet to come into force. The Act is yet to be notified. Number two, under the Act, the government has to make rules for a whole lot of things for which the power has been vested by the legislature in the government. And number three, once the Data Protection Board of India as a regulator comes into once it becomes operational, once it is constituted literally, and once the rules will be framed by the government. After DPBI itself comes into being, DPBI will have to undertake a whole lot of things, and they will have to notify what is known as regulations. And then only we will actually have some semblance in terms of enforceability, compliance, etc. The other thing that I do want to mention is this, that irrespective whether these are rules or regulations, whether by the government or the regulators, they must do extensive open consultation. Thank you.
Yeah, please.
Thank you very much. I think we have a lot to talk about that. I think we need a couple of days to talk about that. So I'll be very brief, and something that interests me as well as I would imagine interests the audience and many of the industry houses would be the idea of consent. And that has come, in different shapes and sizes over time. Right now what we have is kind of resembling what other major jurisdictions have, what they mean by consent. But the idea of consent and how to operationalize is something, it's very different. So how to operationalize consent, in what manner, is something that would be discussed and would be a very sensitive issue in years to come, months to come, and so on and so forth. There have been, and if you go back, often we go back to the European Union and other jurisdictions. If you go back in time, say in 1990s onwards, you go back to some of the white papers and green papers that they have talked about before coming up with the old directives of the European Union. And from that time till passage of e-privacy directive or the GDPR and to the Data Governance Act and so on and so forth, right? Consent has been the focus. Yet, in my opinion, I'm not entirely sure. If you would ask me what exactly do I have to do in order to be on the right side of the law, it's a difficult question. I guess we probably need to have a discussion on that front, but I'll stop here and let Siddharth speak.
Thank you, sir. So I'll just start with just introducing a few ideas that I thought about when reflecting upon the passage of the DPDP Act. One was that the law seems to take on sort of proposals which have been made in international frameworks like GDPR and so on and so forth, but build on it, but looks at it in certain aspects through the lens of technological solutions. So what I mean by that is, for instance, under Section 9 of the Act, there is a provision which talks about the requirement for verifiable parental consent. And there, of course, there have been discussions around trying to make data fiduciaries effectuate that requirement by linking business databases with government ID-based databases like DigiLocker and Aadhaar and so on and so forth. And the approach that sort of comes out when you listen to the discussions that have taken place in closed-door consultations has been that very short duration timelines would be afforded to businesses to comply with those kind of provisions. I think we need to learn lessons from prior experiences, whether it be the data localization provision that we have in the RBI, notified a similar requirement of 6 months timeline for compliance back in 2018, and in fact take a more practical route where the aim should be towards giving staggered timelines for compliance which are actually implementable, so that over time when you're trying to actually bring the law into force, you're trying to do it in a way where you're giving as much opportunity for good faith businesses to comply. A second element that I thought about when looking through the law was the idea that a lot of the actual compliance burden and therefore the liability is placed primarily and unilaterally on data fiduciaries, whereas a lot of the back-end data processing risks actually take place at the level of data processors who aren't the front-end businesses, often interacting with your data principals or internet users. So the way that liability has been allocated is not in a distributed or shared manner. So how the industry responds to that will be interesting to track. The third thing that I really thought about was the idea of inter-regulatory and inter-institutional coordination. Because of course now there will be a sense of a general law that businesses, specifically data fiduciaries and maybe even processors in an indirect way must comply with. But there are of course obligations that take place outside of data protection at a central level which is adjacent as well, which is your cybersecurity obligations under the IT Act. And then you have sectoral obligations as well. So in coordination between all these different frameworks and then therefore coordination between your reporting obligations to different institutions is another sort of big challenge that we need to think about when we're thinking about implementing this framework, specifically the DPDP Act. And the fourth thing was the idea of consent managers, which has now been brought into force through a central legislation. But we've already seen experiments with that at the level of the financial services sector already. And there are notable distinctions in the way that the DPDP Act has approached it and the way that financial services are looking at the notion of consent managers and account activities. So I'll stop at these 3 or 4 big ideas, and of course we can have a
Thank you. I'll pick up on a point, Professor Indranath, that you mentioned, right, about the importance of consent, and this is something that has come up in our consultations as well whenever we've done industry consultations. So concerns around operationalizing consent managers specifically as a new idea. So on that, what do you think was the intent behind introducing the concept of consent managers in the law itself, right? That's my first question to you. And secondly, how is this going to change the status quo in terms of how businesses currently collect and manage the consent life cycle, as well as how users or individuals as data principals are used to giving consent? How do you think this will change that status quo?
Thank you very much for this question. I think it has got several parts to it, but I guess I'll contextualize the question in a manner. Before even we dive into what the law is talking about, let's understand the idea of consent. The idea of consent, it's an age-old concept, right? It goes back in time. I don't, for the positive time, we do not have, sort of talk about what state sovereignty meant, what consent was then, to what consent became. Regardless, it's an age-old concept. The term hasn't changed, but the attributes have. The whole idea is that at the end of the day, if we can reach to the stage where, to some extent, meeting of minds can happen. If that is objective, can we fulfill that in the day and age we are in, and things that we do, and so on and so forth? Let's rewind 20 years, or maybe 25 years. Start of e-commerce business, United States, leading the way. Number of decisions coming out of different circuits, United States. Business has been questioned as to how they are providing information, what kind of notice are they offering to the customers, what is the consent framework, and business has been pulled up because they didn't know what to do, how to notify, and let alone consent and meeting of minds and so on and so forth. So the core issues were that, you have provided the information, yet it seems that it has not passed on to the customer for whom it is meant. Now, and therefore they were pulled up. But the question then, and the question now still remains, can we cage in how we have ideated consent as we did, say 200 years back, and then moved on in time, fast forward, 100 years, 50 years, and where we now, and have the same kind of mapped every aspect of it. I guess we probably would be barking up the wrong tree if we are just mapping all the attributes. What is the central idea of consent as it stands, in my opinion? It's a safety net which provides an inkling of what to expect with the data that you have provided. Right. If we can reach to that stage, we are doing fine. Now, if we want to reach to that stage, we also need to ascertain how do we transpose that idea into practice. And there we probably would have different hiccups. Why do we have hiccups? Because people like us, myself, we tend to interpret and see data differently. Here the nature of the data becomes so very important. So if I receive a message from somebody saying my account has been debited and someone has innocent value, say 5,000, 10,000, 20,000 rupees, probably I would sit up. Instead, it say that, I receive a call from somebody saying, oh, you know what, I want to sell you something. I probably would disconnect the phone and say, I don't need this information. So if we are looking at the nature of the information becomes very, very important when it comes to consent. So what has happened thus far, we have gone about to find the same solution to different problems. So for instance, what Siddharth was talking about, consent manager is surely not a new idea, right? If my memory serves me right, 2020, 2021 is when we had the RBI guidelines. And the idea was to make it seamless for customers. That's the objective. Great. What is the objective now? How do we make it seamless for customers? What is it that we are trying to achieve? I think that is what is extremely important. Financial data, when you are signing off, we're giving consent at a granular level. And now when you're giving consent at a granular level for all kinds of data, becomes very, very important to crucially differentiate between the two. So are we looking at different kinds of consent managers, or are we looking at one? If we are looking at different kinds of consent managers, then it becomes complex for customers and for data principals for whom it's been meant. It also becomes complex for data fiduciaries, because at the end of the day, they have to manage a lot. And nothing, we can't have a rule which works just in a way which favors one and doesn't favor the other. So it wouldn't work. So the idea of consent manager, it seems, is to reduce the burden from both sides. But in the process, we cannot increase the workload. And if that has to happen, first we need to decipher what is consent, what is it that we are trying to achieve through consent. Do we want to imbibe the age-old concept, or do we want to have a filtered approach, casting consent as a merely safety net, where information is provided in a transparent manner, yet it is done quickly, and also relieves the data fiduciaries from the burden of doing multiple other things. I'll stop here and we can.
Siddharth, I think this leads back to a point that you mentioned at the beginning, like the idea of interinstitutional coordination at the central and the sectoral level. So you touched upon this a little bit, but how do you view the consent manager framework under the DPDPA working in tandem with existing sectoral frameworks like the account aggregator or others that exist?
So essentially, when it comes to interinstitutional coordination at the level of consent management, I think one thing that we have to keep in mind is that now, at least under the DPDP Act, consent managers have been assigned a specific obligation which talks about acting in the best interests of the data principles. And then there are certain enabling provisions which essentially say that the central government can create a framework for registration of consent managers under the DPDPA and also create new obligations for all registered consent managers under the DPDPA. Now the problem is that when you look at sectoral consent management frameworks also being set up, for example the RBI's NBFC account aggregator licensing framework that already has a system of registration and licensing already being, which is already being implemented by a sectoral authority. Now in that context, to create another parallel system where these players need to also register with the central government, which could be, let's say, the Ministry of Electronics and IT, that creates a burden for business continuity and business operations. I think at least at the there has to be a running dialogue between the central government and sectoral authorities, including like let's say your RBI, to determine which institution has the capacity to be able to scale a set of consent managers for a particular use case. Now, for example, in the financial services case, naturally the expertise would reside more likely than not with the sectoral authorities, which would be the RBI, which works in conjunction with SEBI, the pension regulator, the insurance regulator, and the Ministry of Finance through a dedicated system of coordination, which is called the Financial Stability Development Council, the FSDC. So therefore, in those circumstances at least, there is perhaps less of a need for MeitY to come out with a registration and regulatory framework for consent managers, but rather just mutually just certify that this is the framework that consent managers within financial services should operate. Now let's look at a different use case, which could be consent management in the context of children's data. There, I think perhaps you may see that the Ministry of Women and Child Development may lack the technical expertise to be able to think through what the technical requirements for a consent management ecosystem should look like, and what could be the sort of North Star objectives for consent managers to pursue when it comes to discharging consent on behalf of parents or on behalf of minors who are below the age of 18. So there perhaps you need to have, in fact, a very consultative process where MeitY works with not only its parallel ministries like the Women and Child Development Ministry, but also with data fiduciaries that build products and platforms for children or adolescents between, let's say, the ages of 13 and 18, as well as child protection organizations. In fact, you need to think about ways where you can upskill child protection and child engagement organizations to be able to perhaps discharge the ability of, discharge the consent management requirements on behalf of teens and adolescents and so on and so forth. So it will be a pretty complex task that we'll have to think about collectively as civil society, think tanks, advisory groups, industry and government to think through how consent management must formulate in different use cases. And where required, I think MeitY needs to delegate that obligation towards technical sectoral authorities because they would have the capacity to best think about the problems.
Thanks. I think that really is a big piece of the law, is just figuring out how consent notice and all of that will work, right? But I'll shift gears a little bit and move on to another possibly controversial, challenging piece of the law that also has a similar problem of coordination between sector and other laws, right? Which is reporting of personal data breaches, which we touched upon. Deepak, I'll come to you on this. How do you view existing breach reporting requirements, say like under the certain directions or under the sectoral mandates? How do these work in tandem with the requirement under the DPDPA to now report personal data breaches to the board? And do you think there are regulatory interventions which are required to make breach reporting less fragmented, more coordinated?
address to something that Siddharth just mentioned about coordination. I think the coordination has to be seen at 3 different levels. One is obviously the DPBI, the Data Protection Board of India, with other regulators. And these other regulators, I'm saying, they could be horizontal regulators. For example, they could be Competition Commission of India, they could be others like horizontal regulators. But they are also sectoral regulators, as he just mentioned, whether it's SEBI, whether you are in the energy sector or in any other sector. So we have that as one issue. Second level of coordination has to be happen, which is at the center and the state level. So because there are a whole lot of things which are come under state utilities, etc. So there has to be coordination between center and state. And third is, because cyberspace is such where there will be inevitably a lot of international ramifications, whether inbound or outbound, whichever way, irrespective of whatever we talk about data localization, etc. The fact is the cyber attacks, ransomware, many of these things are trans-border in nature increasingly. There will also have to be a lot of coordination globally, so which is across the borders. And so I think as far as the Office of the Data Protection Board of India is concerned, one is they need to have coordination with other horizontal and sectoral regulators at the center, regulators at the state level, whichever way they are, and also across the border. And that's why initially when DPPI comes into being, before enforcing anything, I think they need to do 3 different things. One is create major awareness campaign, which is what Competition Commission of India did for several years before they started enforcement. Second is sensitization. And third is even capacity building. And capacity building is not just within the industry. The capacity building is also needed within the regulatory system, both within DPBI but also in many of the other regulators. Look at this way, most of the regulatory agencies as well as many government agencies themselves are some of the largest custodians of personal data. So I think if you have proper institutional mechanisms, good instrumentalities and good intention, what will happen is that these organizations themselves can become role models for others to follow. Because it's not that, okay, the industry should do such and such thing, and the regulators can just sit the way they want. That's one aspect. Now coming to this particular issue that you mentioned in terms of what is the challenges in terms of different type of breach notifications. So let's look at some very simple things. So currently, let's say there's a large bank. Now that bank, if there's something goes wrong, they have to report to RBI anyway. Okay. They also have to report things to CERTIN under these rules which were notified. And also, because financial sector has been one of the 6 critical information infrastructure sectors, CII, in the country, under the NCIIPC. This is the National Critical Information Infrastructure Protection Center. We got already identified 6 sectors, by the way. US has got 17 and a half. I am saying 17 and a half because 17 were already there, and after the 2016 elections, they also introduced the election system also as one of the specific system, and that's why I'm saying 17 and a half in the US. In several other countries, you have different numbers and different types. In India, somehow we are still sitting on 6, and one of them happens to be financial sector. Now, suppose this particular bank's core banking system has also been notified as a protected system under Section 70 of the IT Act. What happens is they have to look at what NCIIPC says. They also have to say what is CERTIN says. They also have to report to RBI. The reporting formats are different across all these 3. And forget about all these 3. Let's come to financial sector only, specifically. So under financial sector, we have got 4 different regulators. We have got RBI for banking and NBFC and for payments. Okay. Then you got Securities and Exchange Board of India, SEBI, for securities, and forward markets, which was also earlier a separate regulator, now it is part of SEBI. We have got pension and insurance. Now, RBI came up with the comprehensive cybersecurity guidelines on, I think, 6th June, on 2nd of June 2015. SEBI had come out with their own stuff separately, and IRDAI had come out separately. Something happened in 2016, 2017. Now the way it is, if you see SEBI, it is at a very high level. If you see RBI, it goes a little bit more into detail. But if you look at IRDAI, it's got a list of some 300 odd items, I remember. Okay? So even if you are working, let's say, in a financial group, so whether it is SBI, ICICI, HDFC, etc., all of them have got multiple businesses. So they are running mutual funds, they've got insurance companies, they've of course got a banking company, asset management company, etc. Typically at the group level, you have a single CISO, CTO, etc. They'll have to perforce have different type of compliance even within the same regulatory sector itself, within the financial services sector, which is the vertical. And apart from that, of course, you have these obligations in terms of reporting to SEBI, to CERTIN as well as to NCITC. And more than that, in case you want to do, let's say, a police report or something like that, FIR, you'll have a different type of reporting requirement. So one simple suggestion is this. Suppose you are financial sector. I mean, yes, you may have SEBI, IRDAI and etc. coming out with their own norms. Can't they, under the same FSDC that Siddharth was mentioning, under that, can't they have a mechanism so that they can come to a common template? Yes, each of them will have something very specific, and that can be the add-on. But let there be a common baseline for that in the same sector. In power sector, by the way, there are 4 certs in the power sector alone. So there are sectoral certs also. And we are talking of AISS and many other bodies. As far as DPBI is concerned, and that's the last point that I want to mention at this point of time, is this. DPBI being the regulatory body, the statutory authority under the DPDPA Act, should create a baseline for every data fiduciary to whom they want them to comply with these norms. Beyond that, obviously, they can be different regulators. They can have their own things which go on top of whatever DPBI says, and not in abrogation or in difference of that. So the baseline should be defined by DPDPA, by the DPBI as a body, and beyond that, others can do whatever they want in terms of specific sector or anything. Second is, I used to work in an ISP company long back, and we had to give some data to both to DoD and TRI. They have different templates. Same data, exactly same data, but different templates. So, and we tried if somehow something could happen. They didn't. So what I did, I created my own superset, and I used to send one, CC to the other one formally, send the same stuff to them, and CC to the other one, because nobody could complain that आपने मुझे वो नहीं दिया जो मैंने मांगा था, आपको वो सारा मिला जो आपने मांगा था, plus something more, and that was my way of handling. Thank you.
Thanks, Deepak. That was really helpful. I do have a follow-up question for the entire panel, anyone who's willing to pick this up. You talked a little bit about the manner of breach reporting, right? How that's very fragmented, how it differs across sectors. Another issue on breach reporting that has come up frequently is when breach reporting should take place, right? The idea of a phased approach, a risk-based approach. So what are your thoughts on implementing that? Is that a fair ask? If it is, then what is this risk-based approach and what is this phased approach that we talk about?
Okay, I'll just lay 3 things about this. Number one, I think not all breaches are same. Okay, so just like traffic violations, not all traffic violations are of the same gravity. That need the same, because if everything is dealt in the same manner, you will have actually no effectiveness, because any regulatory body, any enforcement body will also have certain bandwidth limitation in terms of how much and what they can deal with. Second thing is, obviously, I think there should be a risk-based approach. Third, there should also be some sort of proportionality. So obviously, if there's a big breach, let's say so many million of people, their data gets leaked, etc., that's a different thing. That's something else. But there's another thing here. In some cases, even if there's a breach, and this is what GDPR, for example, does provide for, even if there's a breach, but if you have taken reasonable security measures, for example, having a strong encryption, so yes, data may have been leaked, but then the harm from that breach is not that grave, because you have already done something in that respect. And I think to that extent, the requirement of reporting should not be limited only to the regulators, but also to the data principals. So for example, if the bank's data gets leaked somewhere, it's one thing for them to report to the regulator, but they also should have requirement to report it to the data principals, provided, however, that they, in their assessment, they believe that yes, data principals should be informed. At the same time, it should not happen that, okay, I need to inform the data principals, but before that I need to wait till somebody tells me, okay, now you can go ahead and tell the data principal, because by that time, a lot of harms could have taken place. On the same time, suppose I know about a particular data breach and I do not inform somebody, then the responsibility of that should fall on me, whatever happens during the internet. Thank you.
Thank you. So I think we need to look at the legislation as to where we are going, should we follow a rights-based approach or a harm-based approach or race-based approach, right? Breach itself is very difficult to quantify. So as it stands, even in the European Union, right, a lot falls on the data fiduciaries. They should be able to quantify and come up and inform the right kind of audience. So it could be the supervisory authority or the data subject. But in our case, I think it is extremely important, since we are starting quite late. Of course, there are other sectors we have already worked on. It's very important to not go and assert in ourselves that we will act upon depending on the quantifying the breach. It can only be an assessment. Otherwise, there is a sort of a fairly large penalty that is there, right? So let's not quantify and then work. Let's do an assessment and then proceed. Thank you.
I'll just add to this, and basically my position is that right now the law states that all data fiduciaries need to notify any data principal in case their personal data has been breached, right? I think we need to take that requirement seriously, because data principals, i.e. citizens, have the right to know whenever their personal data has been breached. I think the obligation on fiduciaries should be created in a way where the information is delivered to the principal in a manner where there is also an assessment of the potential harm that can be accrued to the principal. And this shouldn't be a discretionary decision by the fiduciary that under these circumstances I'll notify the principal, otherwise I don't have to. I think given that the type of data that is breached can determine the level of harm that is flowing towards the principal, I think we need to provide them with as much useful information as possible, and then let them take a decision as to whether they need to seek remedy through, whether it be grievance redressal, whether it be through alternate dispute resolution, or whether they need to escalate a complaint to the data protection. So whatever the system of data breach notification is, the principle has to be kept at the center, and we need to create as much transparency and good faith reporting between the fiduciary and the principal, because that is the only way for a data protection law to be implemented in depth and substance, is my opinion.
Just before I hand it over, I think the key word here would be trust in the long run. So I think at no point we can actually lose trust of customers, right?
Yeah, I think that's a great point. It's actually one of the findings of our report as well, where we did an analysis of the regulations globally around breach reporting. So that's true of jurisdictions, most places where it's a risk-based approach, but within that the data principle or the data subject in those cases is kept at the center, and there is information being provided about even things like what you can do to mitigate harms that might result out of the breaches. So I think that we have consensus on that. And we have about 10 minutes remaining in the session. Just quick closing remarks from each of you. I wanted to know, given the fact that there are rapid technological advancements happening, we have new use cases for personal data processing coming up every single day. So how do you think India can ensure that its larger data protection governance framework remains agile? So just quick closing remarks, and we can keep 5 minutes for audience questions. Yeah.
So, first of all, data protection itself has to be seen as a necessary but insufficient. Again, I am saying necessary but insufficient part of a jigsaw puzzle across the whole data governance framework. Because it's not just about personal data. And right now this particular act actually talks about is only digital personal data. So it's personal data and that too only in the digital form. Okay. So there are also of course issues which are about the data which is non in digital form. Secondly, we also have of course a discussion going on around non-personal data. There are also situations when the data, even health data, which is normally regarded, let's say, as sensitive personal data. Of course, today we don't have that definition in this particular law now. But the thing is this, that even sensitive personal data, even a health data, need not be sensitive all the time. For example, let's say if there's an information that, okay, somebody is running a mild fever, may not be regarded as a sensitive personal information, compared to when somebody says that, okay, such and such person is an AIDS patient. Okay? So the sensitivity even in terms of health data could be very different. So it is very context specific. So when we are coming to this whole thing about what is it that we should be looking in terms of going forward, I think what we need to consider are two things. One, the basic principles should not change. Okay, the basic underlying principles which are already enshrined in the law, they should be very much there. And after that, there should be agility, whether you are using, for example, right now there's a lot of talk about LLMs in the AI using a lot of personal data. So whether it is LLM, whether it is something else, I think the basic principles should not be sort of lost sight of. And also, the application has to be context specific and risk based. Thank you.
Thank you. So I think, as closing remarks, I for one would sort of see transparency at the core of everything, and that is a responsibility probably we need to take up and own up and say that I need to do certain things in a correct manner. I'm not saying that there has to be a set standard. The notion of transparency means not many things. With the rapid changing, technology and so on and so forth that we see, that I think everything boils down to transparency. That's one, the core item. Second would be consent, and let's not get into that, and I've already said about this. Let's not get into bringing in consent. We need to understand and ascertain what consent is and what we want to see happening. And the third point is that at any given time, and a lot of stress will be there in other jurisdictions as well on standardizations and codes and everything. There is a reason why, because at the end of the day, you can do as much, both as a data fiduciary and expect as much as data principal. So whether you have consent manager, you don't have consent manager, you have consent manager in different ways and different means. So standardization is a key to many problems, and we have to aim for standardization if we want to see everything going and not harming anybody in the long run. Thank you.
So I'd like to conclude by just building off a little bit on what Professor Indranath was talking about, which is I think that right now the Act as it stands is relying and being a little heavy-handed on its reliance solely on consent and solely on pushing businesses towards adopting anonymization and then saying, okay, now that data has been anonymized, you can collect as much as you want for your processing activities. I think there needs to be a stronger emphasis on building not just standards but also incentives for responsible platform and product design, which is aligned with the idea of privacy by design and safety by design. So I'll give you one example. And I'll harken back to the children's data example I've referred to on a couple of occasions, because we've, at the Quantum Hub, we've recently published a report on children's data consent, right? So there, I think our thinking was that in the earlier iterations of the data protection bills, there were conversations around key data protection principles like purpose limitation, storage limitation, collection limitation, and so on. Now, those references to those core data protection principles are now missing in the final version of the Act that was eventually enacted, right? We need to go back to those principles and nudge platforms and data fiduciaries towards signing on to industry best practice, codes of practices essentially for responsible, privacy by design compliant platform design. And that can be a step towards where across the entire life cycle from ideation to product beta testing to product market fit to product rollout and scaling, data protection is embedded within the core so that compliance doesn't become a challenge as businesses scale. So essentially, whatever those principles were that were talked about in older versions should now be reflected perhaps in future industry codes of practices, and that could be a way for that could be a positive way for the data protection implementation process to start.
Just a small thing. I think what Siddharth is saying is, in addition to that, security and privacy and safety by design and also by default.
Thank you for that addition, and thank you to our panelists. We have about 4 minutes left, so we can take 2 or 3 quick questions. Please specify who your question is addressed to, or if it's open to the entire panel. Can we get the mic in the front, please?
Yeah, hi. So this is Gaurav. I just, the question is for the whole panel. So I think I'll just pick up on the point of the standardization the professor said. So picking up from the standardization, so whether your thoughts are of standardizing only the state and center regulatory bodies, or you're also looking at standardizing the tech stack, the technology stack, which is actually collecting, consuming, processing, or transferring the data. So what are your thoughts on that? That's one. Continuing on that, what I see, I'm from Rickson, so what I see, there's a lot of talk that we are doing today. To me, if you ask me, it looks 5 years old talk. Today, the data breach is happening. We are talking about transparency. If you don't start from the transparency, where will you reach? You will not even detect. Today, but generative AI-based data breaches are reality, right? So now, what are your thoughts on bringing that into the tech stack standardization for data collection across industry or across sectors? And for sure, center and state consent has to be taken, as Deepak said already. So any thought on the standardization?
Can we take a quick roundup of questions, just 2 or 3 questions, and we have the panel address them together? Give them front, please. Okay. Go ahead.
I have the mic. Hi, this is Aishi. I am a consultant and I head privacy at Payroll. So I had the opportunity of seeing the first draft of the rules when Mr. Rajiv Chandrasekhar showed it to a close group of associates yesterday. So a couple of pointers. The discussions were very, very objective in nature. What I would want to add on to the conversation is privacy by design, the requirements of purpose limitation, storage are all coming in the rules. We've seen a part of it. We've seen the entire, I would say the point-wise of how grandfathering has to be done, who, why, when, and how it has to be retained, the login of 3 years, the security. So we specifically raised a question about, going to the certain N6R and under the rules that they are coming up with 72-hour timeline for breach reporting. So the minister also acknowledged it. There was a little bit of resistance in relation to any changes that are going to be done. But we will see when the rules come out, and there will be a period of 7 days given there, where there would be an entire consent artifact which is coming in the rules. So you will have a lot of guidance from there. They will tell you what your notice is supposed to be implemented and what is the exact form and structure of the notice that is required by the regulator, and then you could have your deviations around it depending on the industry that you are using. So a lot of these points, and another one on the breach, it is not a risk-based approach, it is a rights-based approach. Breaches to the personal, any personal breaches to the data principles, you have to give them a standardized format, and you have to take them the remedial steps and the actions that you've taken and how you've counteracted it and what is the level of damage. So it is a very detailed rule that we will see in the next couple of days that are coming out. It's very, very subjective in nature, but at the same time it is going to the core of protection of data principal rights at all points. So it was more of a generic update.
Thanks Ayushi for your input. Unfortunately, we're at the end of time for this panel. Thank you.
Sure, yeah. I just want to, I mean, let's see, as and when the Act gets notified, let's see what the rules actually get notified. We don't know because I mean some of you may have seen, we don't have that privilege. But all that I would say is that no matter what rules, what regulations, it would be best if there's a proper, transparent public consultation. Thank you.
Thanks, Deepak. Thank you to the panelists and the audience for an engaging discussion. As I mentioned earlier, over the past few months, the DSCI team has been working on a set of reports which delve into some of the issues that we've been talking about over the past 45 minutes. So it is my pleasure to have our panelists be a part of the launch. I'll now invite Mr. Vinayak Godse on stage, who is our CEO, to talk a little bit about the significance of the reports and is already mentioned in the beginning, but briefly the work that DSCI has been doing in the data protection space. Thanks over to you.
Yeah, so as I was talking in the morning, so these deliberations of privacy for each industry is not going to be easy, right? And while I just heard about the breach reporting, right, and how difficult it could be in the very unbundled ecosystem that we are, right? Because nobody does everything in the organization. There are a lot of third-party interfaces, APIs, vendors coming to picture, and breach reporting will be such a difficult part. And we also see now consent, where it has been discussed in the conflict. What is the consent itself is a challenge, and we are seeing that challenge in GDPR, but consent manager case, there is another layer of challenge that we introduced in the country, right? So the implementation nuances are very tricky. In fact, we recently launched this DPO course of DSCI. We spent an entire full day to look at the nuances of implementation, architecturally, procedurally, administratively. And we also try to look at how in different areas, in health sector, in insurance sector, in banking sector. So last year we spent a lot of time to do sectoral privacy initiatives, and there are a lot of reports published on this particular part. So this report just compile some of the effort that we put together to go to nuances from the implementation and overall ecosystem perspective. And you would find it useful because a lot of practical things are there in terms of implementation. And there are a lot of anonymization is already government is working for standard anonymization. There's already AISS is working for this. So this is kind of input from the industry for that effort that government is putting together. Last year they did, but there's again going to go. So we will look at this as well. So once rules comes in, then we'll also see a lot of challenges coming in that. Hopefully we get some time for that. So how you're doing to do this? Yeah. So I'll request all of those people and AISS and
Thank you so much to our panelists and the audience for taking this an engaging discussion. I'll hand it over to Deepika to take the discussion forward.
Thank you, panelists, for that very insightful discussion. And I'm sure I speak on behalf of everyone where for you to expound your thoughts on not just data regulations in terms of the perspective of the data fiduciary, but also your perspectives on in terms of the implications for the data subject as well were really were very well articulated, and also considering that you also expounded on the views of the DPDP Act in terms of how the sectoral considerations also come into play were also very well received. So overall, it was a very wholesome discussion, and I thank all the panelists for lending their expertise and lending your time for this very impactful event today. So, and as Vinayak sir put it across, we could have asked for a more opportune moment to also have our report launch here today. So, thank you again for the very insightful discussion. So, moving on with our agenda today, I also would like to take this opportunity to announce some very exciting academic and industry collaborations that the DSCI policy team has been doing. If I could request the technical team to please put the next slide, please. So in the interest of time, I would like to announce that we will be the DSCI policy team. It's my privilege to announce that we will be having the second DSCI and the National Law School policy case competition in the year 2024. And this is a very strategic academic collaboration that DSCI will be doing. And to give you an insight into what exactly happened in the previous year, so the competition last year specifically dealt with how blockchain could be used in land titling in India. So this was specifically a pilot study that was done in many areas across India. And so we essentially wanted to know that since it's such a novel and upcoming issue, we wanted to know whether there could be any policy around it. And I'm sure that many individuals from the audience right now are from the legal fraternity. So I know that you can resonate when I tell you that we as law students, while we were growing up, there weren't many policy competitions back when we were in law school. So you could say that there were an umpteen number of parliamentary debates, there were an umpteen number of moot court competitions, but really to build that fervor within the legal fraternity and the next generation of lawyers, we have seen that there wasn't really a fervor to ignite in their minds or to really consider policy as a career option. So we really felt that DSCI should be taking up this initiative. So we did collaborate with one of the best law universities and one of the best law firms in India to do this particular initiative, to actually really build across that indelible mark that is required to really nurture the next generation of technology, policy, education and careers. So, our vision essentially for the next edition of the NLS policy case competition is to highlight the theme of emerging technology and at the same time also to cultivate the multi-stakeholder approach in policy. So, I'm sure all of you know that policy is not just a single stakeholder, really like a single stakeholder venture, and you see that there are many nuances that come into play and there are multiple stakeholders that come into play. So we really felt as an industry body, we really need to ensure that young and budding policy professionals have that particular mindset. So again, the point that needs to be driven home that this initiative is not just a competition, but it's essentially a journey that empowers, educates and connects individuals. And DSCI, through this competition, we want to lay the groundwork for a future where technology and policy seamlessly converge. So this was essentially a key pillar of the policy team and how we wanted to engage with academia. So we're really proud to have been part of this initiative, and we're really proud of how we've executed it. And in fact, we attracted multiple students from leading NLUs and IITs to be part of this competition, and we're really excited for the coming years. So please do watch out for the second NLS policy case competition, which will be held in 2024. So, and we will be releasing the dates and the problem statement and structure soon. And the reason as to why we're announcing it here is that we could have asked a better moment to like really have all the best minds in technology policy and the lawyers and the people from those technical backgrounds to be in the same room. So if you have any input for this particular competition as to how we can really nurture the next generation of technology policy advocates and researchers, please do reach out to us. We'd be happy to collaborate. So, moving on, I would also like to announce exciting industry collaborations that DSCI has been engaged with. So, for those of you who do not know, Cypher was an incredible collaboration that we have maintained with Ashoka University, and we're excited to continue this collaboration. So, again, to give you some backdrop as to what Cypher is. So, Cypher started in 2021 with the goal of preserving privacy and utilizing encryption as a tool to preserve privacy. And since then, we've grown our coalition and we've expanded our partners. So, and we realized, and with Cypher, we realized that privacy is a much larger conversation. So, this brings us to our much anticipated initiative called Next. So, Cypher was essentially a rebranded version. So, Next is essentially a rebranded version of Cypher. So, and to reiterate, Next has been a long time in the making, as Cypher really started off as a coalition of legal cryptographic technology. But we realized that privacy is not just a conversation for today, but also a conversation for tomorrow, as what our panelists also reiterated in the discussion before. So that's why we want to focus on emerging technology. So in essence, it is Cypher, but it's expanding its mandate. So with this, we have many exciting projects and deliberations and academic and industry collaborations that is going on here at DSCI. So if you do have any sort of interesting ideas to contribute to the policy team, please do reach out to us. I would now like to hand it over to Ms. Deepa Oja, who will take us through the policy landscape here at DSCI.